get to which. Okay, we'll pick up this argument in the second half, ma'am.
Yes, ma'am. Yes, ma'am. Thank you, ma'am.
Defense has contacted, he's on the way.
On his way. Yes, ma'am. Yes, on. Good day, Honor.
Good to hear. Bhairav, do you have any matter?
Yes, Anna.
Is Sennacherib your case?
Yes, Anna.
Oh, it's Apu. Sennacherib. Where's Apu?
No, no, ma'am. It's Pandit.
Okay.
Pandit.
Grigjang Shira has not come, huh? Who's the defense?
Yes, Anna.
Defense also.
So Pandit, ma'am.
Hey, Grigjang it's by Pandit, yes. So Pandit, he has contacted,
Yes,
he's on the way. Oh, maybe
Okay, ma'am.
evidence, he will bring the witnesses. He contacted PP, he said he has got evidence today. Since he has come personally, I
Ma'am.
think witness will be there. DWs.
Ma'am, so today is only for filing of the list of DWs, ma'am.
I don't know, let's see. Let's see, the defense.
Yes, ma'am.
Is it yet to reach? Who contact me? I don't know. You go to the. What is the other case? Kali na po, support dan witness na. Edit lah kontak. Sili coming. He also on the way. Sennacherib, leader occupation na. Ada nanti. Is there any evidence? Are you supposed to come?
Yes, yesterday she was confirmed that she will be coming. This morning she called me that it seems one dead body was brought here to Mokrot. Seems to be a murder case. So she is busy in the requisition.
Is he not?
So
Is he not?
in that investigation, because there is no
List.
SIS. So she is
She will
busy.
not come
She will
out.
not be able to come. It seems.
Okay. You said Piong Filajofi Lawan Hananti.
He is coming, he said.
Okay. Accused Sri Sennacherib and Regent Wano are present with the defense shooting. Bishop PP, AT is present and he submitted that the IWBS IMRI has informed she is preoccupied. New case, no?
No, this is the last witness left.
No, she's preoccupied with the new case.
Yes.
With the new case. With the new case, as she is the loan to one police. At this time.
The message goes like this. She has to attend one murder case in Mokrot. That's what she said.
Okay. So what you'll do, you'll inform her the next day.
Yes, you need to send someone.
But I think we better issue quite a summon.
We can inform her also. No problem.
Okay, we issue a summon. When will be the next day?
I think better I just discuss with the defense. So otherwise, I think the date he might not be okay. I'll just let you know.
You have seen the defense counsel. Some
No, he's not. I've not
he
seen him.
told us that.
No, I called him in the morning just to inform that the witness is not coming. So if you don't want to come, that's okay.
Yeah, just ask us.
So he's coming.
Maybe the next day.
Yes, sir.
You think so, but we have not. Yes, because of the communication. 28 case segment. Bisa sheets na harap. Kaya. Tuloy. Sure. Wakot tuloy pa lang ang case. Wakot tuloy na. At ang naman. Yan fix no. Ako pratari mo. Mas sasang mo sa kijo. Nanto la ya ke jinjuba tu pisian nanto re pia ko anda sakina ya kijo pin ko. Raya admen. Si ông yêu ý thì ông fully to defense aku pratari. Nama anda kisah. مش بقصد بالنسبة كان المفروض Proceedings also done case now proprietary. I don't know what is happening on 28. PP2 she said she had put mediation should not. Or that at least. She may be the data to come to spouses coming problem. If you do that, it will be so easy like that. Uh, 28.
Yes, sir.
Yes, right?
I informed you. It's okay.
Because I've got no case on 28. I
It's okay.
want.
Even the I also said short date is okay.
Yes. We should summon 28.
So the court someone will be sent from the court again.
Yes.
Yes.
We should.
Yes, yes.
You've got only one case.
Only one case. I was ready to come that moment only. I received call from her that. So that's I am already ready. So
Very good to come.
yes.
Meanwhile, you can check. Because she'll be the IO, no? Meanwhile, you can check the case you got because she'll be the IO.
Yes, but this case, you also saying that I have filed a charge sheet just based on the statement of the victim, nothing else. Even the DNA report also came negative. What do I do also with this case? So now the entire exercise of calling 29 or 22 witnesses is futile, I see. But what to do? Just to do the formality. It took so much time to call all these 22 witnesses.
I feel sorry if that is the case. I feel sorry for the person who just drag on.
Yes. And most of the disability cases, witnesses are 20 plus always. Less witnesses are not there. They also in the process, they need to come every day.
I have a problem with it. If there is, I don't know, I'm not judgmental. I don't know what would be the fate of this case. I don't remember anymore. So many cases are there. What was the evidence there? I don't recall.
Even the last date,
But if there is a benefit of doubt, then I used to consider for helping the victims with the compensation and all.
the statement goes like that, her friend, his friend, the accused friend called her to go such and such place. And
So that
she
one,
went there. This is the case actually, where the DNA report came negative.
but she gave birth. A child,
child died. Child died.
juvenile.
Child died.
Child died.
Yes.
But nevertheless, DNA report came that juvenile is the father. Is this the case?
No, no, no. The accused
Got mixed
DNA.
up. See, I got mixed up.
The
because
accused DNA is not available only in this case.
There's only
It's-
one case only here.
Yes.
No, she's the same person. Another case is there.
I think there.
Another case where juvenile file against her.
I think there.
She's the accused in the other case.
Yes.
The juvenile file case.
There-
Because why DNA of
Yes.
the child is father is the
Juvenile is the father. It seems there.
juvenile claim that she is the
Because
one.
when the FSL expert called me, she mixed up actually both. She said that it has come positive and this is the case number. I said that, so madam, this is not the case number. This case number is something else and the accused is here, Senakari. And she said that the same sample, it seems like it's sent because from the dead body cannot be sent twice. So they have the basis of the DNA of the child is only one. So they have considered from this case also and the other case also. So there with the juvenile, it has come positive. And here the accused is negative.
Negative.
This is the same case.
Very peculiar case.
Yes.
The juvenile file case counter cancer.
Just to save himself also, I think. Otherwise, but again,
Well,
but then otherwise also it will not fall under POCSO because.
Disability certificate is there, no?
Yes, it is there. But
Let's see.
this
if,
disability certificate also brought later. This was.
Anyway, after the evidence, I will.
I don't think this was exhibited also because when the victim and all were called, even the parents of the victim also, this certificate was not there. So
He did in trial.
yes, so the only option left is when the IO comes, I can exhibit this.
This case was transferred to you by PP.
Yes,
Or earlier taken up by PP as
Yes.
generally.
generally.
But later on she brought.
Later on, the IO brought the disability certificate and
Not IU, the Parada.
yes,
The Parada brought.
yes. So, and another application was filed by the PP. That's it.
Okay. Let's see.
Yes, to just
So see you on 28.
yes.
You have come forward. Oh, observe. Huh? I have more defense. What I need defense. She found one lawyer to be. Otherwise, his defense is super.
Yeah,
His defense, their defense is
I didn't.
His regular, he used to come.
Yes, yes, yes.
This expanded, I think, whether he has switched or not. Did you see expanded?
I didn't see him.
The junior said he has already moved on the way, but has not reached. Wait, Lloyd, at what time? At what time was before? From Wayloi till here 1 hour.
45 minutes. it
What
is.
for, let's see for them.
Yes.
For you and me, we've been visiting here every time, so we know. But for them,
For them, it takes time.
they used to come once in the blue moon, so it will take time.
So because of the fog and all, well,
Yeah, and now it's foggy. Yeah, Wayloi especially.
Yes.
By
Value
4
to
p.m., by
till
4 p.m. it will go, then it's dangerous. You'll have to wait for a truck to go behind the truck.
one of
Even the headlight will not be able to, not visible. The,
one of my friend, he came here Mokorot once. While going, he had a tough time. He had to stop the car. In fact,
last time also we stopped the car on the road. We had to, and that area, where it's foggy.
till
24
till
hours.
till Tirsad. From Value to Tirsad is most of the time it's like that. Day is sunny, also still it's foggy. That's it. So I have been coming regularly. That's why I have visited. Otherwise, it's difficult to write this room.
You are the LATC? You are the LATC?
Intern.
Intern. It so happened today we have less case. Witness also, I don't know, witnesses are taking time to come because of the foggy situation. Out here, last time we had to stop the vehicle twice. Starting from Ungi River, it's foggy.
This
Then
side,
dangerous road.
this side is like mostly it's not foggy.
No, last time it was. It was even here, so I couldn't see from here. I couldn't see my water. And so
Sometimes
dense fog. Then there at the Mauplang also.
from side.
Twice we stop the car.
Especially from Wildlife to this side, it's very zigzag road. So if it is foggy, it's very difficult to drive.
Now we like to 24 hours.
Yes, but that side road is good now.
24/7.
That side road is good now, so it's okay.
But then the only thing is that during summertime like this, it's more dense.
Yes.
Even in daytime, you have to stop the car.
Daytime also.
Yeah.
While coming or while going?
Well, going.
See, will.
Well, going or while coming, same to same. It's same spot.
Same only.
Mariana, is there any witness?
Yes.
Has come?
Through VC, yes, ma'am.
Oh, has come.
Yes.
So defense has come.
Even him through VC, he's ready.
Ready?
Yes.
So we'll do one thing. I'll go to for you to stand. Okay.
Highly obliged. Good day.
Barab.
Yes, ma'am.
In the meanwhile, I'll go to postal court for evidence. I'll come back here. The defense is still on the way.
Oh,
It's still
Okay,
on the
ma'am.
way. Has not yet reached. Okay.
Yes. Yes, Your Honor. Your Honor, I have submitted my written argument on the last date, and
You will rely on the same.
I rely on the same.
Okay. Whether you will submit written argument or
I will just file, I will just do oral.
oral?
Yes, ma'am.
Okay, so he will do oral. Whether you need
Yes,
her to open orally? You need her to open orally?
Yes, Your Honor.
Yeah, can you give him brief
Yes, Your Honor.
orally?
Yes, Your Honor.
Yes.
The prosecution respectfully submit that the charges were framed against the accused persons under Section 22C of the NPS Act against the accused Pranjal Marak and Section 29 of the NPS Act against the accused Korijan Sangma. The prosecution has examined 11 witnesses and exhibited 6 documents along with material exhibits. The brief facts of the case is that on 4/2/2022, while acting upon information received by BSF personnel stationed at Borsora BOP, a Naka checking was conducted near gate number 2. At about noon, the accused persons arrived on a Bajaj Pulsar motorcycle. The accused Korijan Sangma was driving the motorcycle, while accused Pranjal Marak was the pillion rider, carrying a black shoulder pouch. When intercepted by the BSF, 2 persons standing on the Bangladesh side fled towards the international border. The suspicious conduct of the accused, coupled with the conduct of the persons across the border, compelled the BSF to search them. On search, the black shoulder pouch carried by accused Pranjal Marak contained 15 blue packets containing altogether 2,850 suspected Yaba tablets. Besides the contraband, the followings were recovered: the Judge Pulsar motorcycle, 1 Vivo mobile phone, 1 Poco mobile phone, Bangladeshi SIM card, Indian SIM cards, voters ID cards, and Indian currency. The BSF immediately informed Nonghala police station. Then when SI reached the BSF camp, he received the recovered articles, conducted preliminary testing, which indicated methamphetamine, arrested the accused, and completed all the legal formalities. Samples were subsequently drawn on the orders of the learned magistrate. The samples were examined by the BSF Guwahati. The scientific expert confirmed the presence of metal.
You mean to say
The
CFSL?
scientific expert.
Okay.
Yes, Your Honor.
You mean to say CFSL? You said CSF Guwahati?
Yeah, I got it. Yes, yep, I got it. Then, consequently, the charge sheets was filed. The appreciation of the evidence of the first witness, Sonal Bora, he was the complainant at the relevant time towards the assistant commander, BSF. His evidence inspires complete confidence. He categorically disposed that the accused were intercepted near gate 2. Pranjal Marak was carrying the black pouch. On opening the black pouch, 15 blue packets containing suspected Yaba tablets were recovered. Korijan Sangma was driving the motorcycle. Both accused were apprehended together. The articles were handed over to the police. Police received the contraband. Preliminary testing was conducted. FIR was lodged immediately. He identified both accused, seizure memo, FIR, mobile phone, voters card, currency notes, and master packet. His testimony remains constant on the core facts. The defense has attempted to highlight certain omissions regarding recording of source information. It is respectively submitted that these omissions do not affect the effect of actual recovery. The Honorable Supreme Court has constantly held that where recovery is otherwise proved by trustworthy evidence, minor procedural irregularities do not demolish the prosecution case.
Did you submit the
points
citation?
of determination.
Did you submit
The case, ma'am,
the judgment from
the Supreme Court case, ma'am.
which you are relying upon?
No, Your Honor. I'll be submitting. I'll be submitting, Your Honor. I'll not submit.
Okay.
Okay. Then the prosecution specifically submits the following questions arise for determination: whether accused Pranjal Marak was found in conscious possession of 2,850 Yaba tablets, whether the seized tablets were proved to contain methamphetamine, whether accused Kurijan Sangma knowingly participated in the transportation of the contraband attracting Section 29 NDPS Act, and whether the prosecution has proved the case beyond reasonable doubt, ma'am. I stress on these points of determination, Your Honor. Then PW2, Kumar Mandal, he stated that he was a member of the Naka party. Checking, he corroborated PW1 in every material aspect. He specifically stated 2 persons arrived on motorcycle. Pranjal Marak carried the shoulder bag, the bag containing 15 blue packets, each packet containing pink tablets. Police reached the camp. Preliminary testing was done. Police seized the articles. Thus, PW2 completely corroborates the PW1. Minor discrepancies regarding the exact timing or number of personnel are natural, affect passage of nearly 3 years. Such discrepancy actually strengthen the credibility of witness because they demonstrate absence of procuring. Evidence of PW3 Inspector Rajiv Prathi. He was another BSF officer. He also stated source information was the accused intercepted Yaba recovered. Police prepared seizure memo. He seized the seizure memo. He signed the seizure memo, although he could not remember. Yeah, although he could not all the yes, ma'am. Although he could not remember every minute details due to lapse of time, he remained firm regarding interception, recovery, seizure. His evidence further strengthened the prosecution evidence of PW4. Also fully supports prosecution. He clearly stated information was received, team proceeded for checking, accused intercepted, body search conducted, blue packets recovered, accused brought to the BOP, police informed, police took custody. Then PW4 identified both the accused, his testimony independently corroborate PW1, PW2, and PW3. All the 4 BSF witnesses unanimously established all the 4 BSF witnesses unanimously established the following facts. Both accused were traveling together. Accused Prohibitions Sangma was driving. The accused Pranjal Marak carried the shoulder pouch. Yaba tablets were recovered from the pouch. Accused failed to explain possession. Articles were immediately handed over to police. The defense could not impeach this central part of the prosecution case. Their cross-examination merely points out minor discrepancies. The cross-examination merely points out minor inconsistencies regarding timing, exact number of personnel, and procedural details. It is No material contradiction affecting the recovery has emerged. Appreciation of evidence of police witnesses and scientific experts, PW5 in a non-inquiry officer. The police officer who first reached the BSF BOP after receiving information from the officer in charge, Nahalam. His testimony is significant because he speaks to the official police action immediately after the apprehension. On receiving information, he stated that on receiving information, he immediately proceeded to Borsora BSF BOP. Shri Sonal Bora handed over the accused persons and the seized articles to him. He received the entire case property under a seizure memo. He counted the seized tablets and found to be 2,850 suspected Yaba tablets. He conducted a preliminary field test which gave a positive indication of methamphetamine. He took both accused person for medical examination. He prepared a sketch map. He handed over the accused persons, the seized articles, and all relevant papers to the investigation officer. The master packet, PW5 also identified the master packet, the seized mobile phones, the recovered articles, and the seized narcotic substances. The defense highlighted certain procedural omission during cross-examination, including the absence of independent witness, non-preparation of panchnama, and non-compliance with the 13 NDPS procedural requirements. The prosecution suspectively submits that these admissions do not destroy the prosecution case. PW5 was not the officer who affected the original recovery. The recovery had already been made by the BSF. His duty was confined to taking over the accused and the recovered articles, conducting the preliminary tests, and ensuring that the investigation commenced in accordance with law. The essential facts remain unshaken. The contraband recovered by the BSF was handed over intact to the police, and there is no suggestion that any substitution or fabrication occurred. Evidence of PW10 CFS expert. He stated that he is the scientific officer of the CFSL laboratory at Guwahati. She is an independent expert witness with no connection to the investigation agency. Evidence conclusively established that the sealed parcel was received intact. The seal with the specimen seal and the exhibit were analyzed by.
Okay, so you are saying
And the
in
color
this case,
test.
okay, the scientific examination is with a positive test of methamphetamine and caffeine.
Methamphetamine.
Okay, the
And
thing is
caffeine,
that,
yes,
the thing is that
Then the
you admitted here the seizure, the initial process, seizure and conduct of search and all was done by the BSF. So when everything
Yes,
was
ma'am.
done by the BSF, thereafter only the police had come.
yes,
to the BSF.
the police seized from
Police.
the police seized from the BSF.
Okay, I would like to know the police did not go to the PO. The police did not go to the PO. They took over the case from the BSF. They took over the
They
case from
later go
BSF.
to the PO, ma'am, but we took the
Okay.
case from the BSF.
You said the Honorable Supreme Court judgment. What did you say? Honorable Supreme Court judgment. It says non-compliance of
With
those
small,
procedure does not affect the prosecution case.
Yes, ma'am. So
Have you gone through the
Yes, ma'am.
constitutional bench, the judgment of constitutional bench in Vijay Singh, Chanduba, Jadeja versus State of Gujarat? Have you gone through the judgment where the constitution bench held that strict
No, ma'am.
compliance with section 50, it should be there? The right to be searched
for
before
NDPS
gazette officer
section.
or magistrate?
Yes, ma'am.
Have you gone through the landmark judgment of Karnal Singh versus State of Haryana,
Yes, ma'am. Yes, ma'am.
where it says if
Yes,
total non-compliance cannot be ignored?
Total compliance. Yes, in NDPS cases.
Whether
Yes,
any inventory list was made, whether any sampling was made. There is a judgment in Simanjit Singh versus State of Punjab.
Yes, ma'am.
Have you gone through that?
Yes, ma'am. There's nothing.
I don't know whether this has been.
Yes, ma'am, it's there.
Okay, regarding section 50.
Yes, ma'am,
Regarding
those
section
evidence.
50, judgment of the Constitution Bench, Vijay Singh, Chanduba,
Yes,
Jadeja
Yes, ma'am.
is there. Regarding
Yes,
section 42, Ranmau judgment, Karnal Singh versus State of
Yes,
Haryana,
ma'am.
which says total non-compliance cannot be ignored.
Yes, ma'am. In the NPS cases.
It says total non-compliance cannot be ignored, but is there any of the procedure which has been complied? If not total, maybe some compliance was done in this
Yes,
case?
ma'am. Yes, ma'am, some. Not total.
Regarding section 42,
Some compliances, yeah.
section 42 regarding information. If they cannot relate the
Section
information
whether
to
they-
the higher authority right there at that point of time, at least before the accused is produced before the magistrate, have they done? Have they
No, ma'am,
related? Have they related
the place of
information?
recovery was an open road, ma'am, public.
Was it a chance recovery or was it on source information?
A chance
Chance.
recovery,
Then
ma'am,
you said just now,
because they are
you
checking.
You read just now the evidence of PW2, if I'm not mistaken, where you said he received the source information. Just now, you're reading the evidence of PW2 about the source information that he
True.
received. Nay,
Each bank
PW3,
with the police.
PW3 Inspector Rajiv Rathi.
Source immature, sir.
Yes, he
Right.
received.
Source information was received, accused intercepted.
Yes, but
He also
what
stated
have they done with the
accused,
source information? Have they written it? Have they
didn't
related to
write.
the higher authority?
No,
Okay.
no, ma'am. No, ma'am.
Okay. So you have any further submission? Is the scientific expert
No,
last witness? Apart from the scientific witness, is there any more witness?
Yes. After scientific witness, there is the investigating officer, PW11.
What is the name of the investigating officer?
The IO is Shri
What is the name?
Iskatrai.
Oh, Katrai. The evidence of S. Katrai,
Chakra, yes, ma'am.
who said everything has been done by the
Yes,
BSF.
ma'am. BSF, yes, ma'am.
Then thereafter only that his subordinate SI Eleanor had gone to BSF camp and all that, no? Okay.
Yes, ma'am. Yes,
Okay.
ma'am.
Apart from that, do you have any further submission?
Yes, ma'am. No, ma'am.
Do you have any further submission?
Only this one.
As
no,
per
no,
your
no.
written argument,
So,
you
so
are writing
redemption.
something about conscious possession. What is that? Conscious possession for the pillion rider.
Yes, ma'am. Pillion rider,
Liability under section 29.
it's,
Okay. I wish you will, you brought the Supreme Court judgment where you said minor contradictions, omissions, abnormal errors of memory are natural and do not justify
Yes, ma'am.
rejection.
I'll bring, ma'am.
You'll be
Yes, ma'am.
bringing.
Yes, ma'am. But they are for other cases, but not NDPS.
Oh, like that. There is a special provision now for NDPS. That's why it's called special NDPS case. So
Yes,
you
ma'am.
think generally,
Yes, ma'am,
then how will
because
you?
there's no next.
There are some cases where there are presumptions. There are some other cases which do not require presumptions. So, see,
Yes, ma'am.
I mean, like, accepting POCSO and NDPS, do you have any other matters? Do you have any, is there any other type of cases which presumption can be drawn? Okay, nevertheless, that's why it has its own special procedure.
Yes, ma'am.
Procedure of NDPS
Yes, ma'am.
to the Supreme Court is there, it says, yeah, the judgment it says mandatory
Yes.
for section 50 and even for section 40, Colonel famous landmark judgment, it says total non-compliance cannot be ignored.
Yes. Yes, ma'am.
Okay, I don't know what judgment you have
Because,
brought. If you are saying the judgment is of any other general IPC or BNS, I don't know how you will come to this. How you will
yes, ma'am. It's just there's no
NDPS matter.
So
what is your prayer? What is your prayer? What is your prayer? To convict?
A prayer is that to convict both the accused, Your Honor.
Okay, give your reply, Pandit.
May I please, Your Honor? This case is based on source information. PW number 1, my lord, Your Honor, who is the complainant, who has lodged the FIR. As per him, initially, he has in the FIR also he has stated that this case is based on a specific information. In the cross-examination, he declined initially, but when it was confronted, he said that yes, the case is based on source information. Once it is get confirmed, Your Honor, that the case is based on source information, that means the officer has to comply with the provision of section 42, as Your Honor has rightly pointed out. 42 provides that, Your Honor, the source information as well as the reason of belief on the source has to be reduced into the writing, and that has to be forwarded to his superior officer to maintain the sanctity of the information. And that information, Your Honor, it was not exhibited also, and neither at the time of forwarding the accused person, Your Honor, when he was forwarded for the first time accused, the IO has to forward some documents, seizure list and everything. That time also it was not produced, that source information for senior note also. And moreover, it is admitted it is not been exhibited and has not been reduced into writing as complainant has admitted. So now comes, Your Honor, the seizure.
Hence information not reduced.
Not reduced. He has admitted in the cross-examination also it was not reduced.
Okay, no doubt, the BSF can in certain areas within 50 meters, if I'm not mistaken, 50 feet or meters, okay, I'll check. BSF also has the power.
Power is there.
Legislate.
Yes.
Only in few states.
Yes.
Our state is there.
Yes.
But the thing is that
But they have to
they
follow.
have to apply.
Yes, that is the thing. I'm not raising their jurisdiction.
Okay.
I'm only saying that they have to follow the procedure.
Yes.
So now, Your Honor, this officer, he has gone to the PO, and now according to his information, there was some dealing was going on, so he has gone. But the thing is that, Your Honor, he has also not produced anything that he was authorized, or whether anything on evidence also it has not come that he was especially powered under the gazette notification. PW1. No effort has been made by the prosecution also to bring on record or evidence that he was so empowered to go for this checking and all, for vehicle checking and to intercept the person on the information. This authorization is not there. Now, Your Honor, after 42, it has not been complied. Now comes, Your Honor, 50, section 50. Now, as per the evidence, Your Honor, it is on record, Your Honor, that of course it has been alleged that both the accused persons were searched. It is alleged in the evidence that the contraband was recovered from the bag of one of the accused person, and that bag he was wearing, one of the accused. But the thing is that even if suppose, Your Honor, presuming that the bag is not a person, but here in this case, admittedly, Your Honor, they have this person and the other witnesses also, the complainant as well as other witnesses also, they have said that body search was also done. So once the body search was done, Your Honor, it is admitted here also that no option was given to the accused person to
to choose their right, whether they wanted to be searched before the magistrate or gazetted officer. So this,
But no proof, no?
no proof,
No
but
proof
it is,
of-
yes,
of,
providing opportunity
no proof of providing opportunity.
uh, to search, whether they wanted to be searched before the gazetted officer or before the magistrate.
It is not
Yes.
whether.
So section 50 also has been violated, Your Honor.
And section 50 violated.
Yes, ma'am. Now, Your Honor, the search and seizure. As per section 51 of the NDPS Act, Your Honor, the search and seizure has to be done according to the CRPC. Now, once search and seizure is done, the two persons from the area, independent witnesses has to be there. It is not a case of chance recovery, Your Honor. If there was a source information, ample opportunity time was there that they should call for independent witnesses.
There's no independent.
No independent witnesses has been brought. All they were from BSF. And reason has also not been given, Your Honor, in the entire case, that why they did not call any independent witnesses from that area or from anywhere.
No reason.
No reason has been given. Now, Your Honor,
Yes.
then the seizure list has not been prepared on the spot. No seizure has been made on the spot. If the complainant was so empowered, Your Honor, then he should be aware of the provisions, and it is not an excuse that he was not aware. The law provides for that then and there seizure list has to be prepared and one copy has to be given to the accused person also. And not only that, Your Honor, search and seizure, once a document has to
No
be,
copy given even to the accused, no?
it was not prepared only. Seizure list has not been prepared on the spot. So the question of giving also does not arise that it was not given. So now, Your Honor, if the independent witnesses are not there, suppose even if they have conducted the search, the BSF, then from his team also members were there, but no Panchanama was also prepared, recording the procedure or recording the entire episode in the document. So this has also not been done. This Panchanama was also not prepared. Thereafter, Your Honor, it is claimed that this accused person were taken to the BSF camp. Now, Your Honor, this accused person were taken to the BSF camp. From there, some witnesses, they have said, Your Honor, that police personnel were informed. So if police personnel were informed, Your Honor, some witnesses, they have said that police came, and some witnesses, they have said, BSF witnesses, that they went to the police station. So there is a contradiction. Now they have exhibited one seizure list.
Okay, some said that police came on.
Yes, yes.
Came to come on.
Yes. And some they have said they are not aware also that whether police came or not. And some they have said,
Other witnesses said were not aware, no?
yes,
Whether police are come or not.
yes. Now,
Come or not. Did they say rather BSF went to police station?
hand over, yes. To hand over the accused as well as the article.
So at our first station,
Yes. Now, the seizure list, Your Honor, which they have prepared, the seizure list is prepared of seizing articles from the complainant. Here also, Your Honor, it is not evident that this seizure list was.
Session was prepared by PW1.
No, PW1 has not prepared. Police has prepared.
Session is prepared by police.
Police, yes. Recovery of articles from the Sonalpura, in the complaint.
From the complaint.
Yes, yes.
Session is prepared by police.
Police.
To have seized from PW1.
PW1.
Okay.
So
And
now,
not from accused.
yeah, not from accused. And it is also not evident that this seizure list was prepared because there is no signature of accused person. And it has not come in the evidence whether this seizure list was.
No evidence of the seizure from accused.
No.
Seizure from
Accused person.
accused.
Yes.
As his signature is not there, no? As their signature not there.
You see. Now, even if this seizure list, Your Honor, the articles, the tablets and the blue packet where this contraband was handed over to the police, it is not reflected in the seizure list. I will come to that.
Where the articles were handed over to police, not mentioned, no?
Yes, sir. So this seizure list, Your Honor, there is no evidence, Your Honor, it is between BSF and the police. So there is no link or related evidence that it was so seized from the accused person.
No link to the accused.
Yes, no link to the accused. Now, after the seizure list, Your Honor, it was incumbent upon the police to prepare their own inventory list as per section 53. Sorry. 52A. After 51, Your Honor, it comes 52.
Yes.
Thereafter, this inventory list as
Inventory list was prepared in this case or not?
no, not prepared.
But, inventory is prepared, no?
Yes, sir. In the oral evidence, Your Honor, the witnesses they have said that it was forwarded to the magistrate for certification, but in evidence it has not come, Your Honor. Yes.
So, who said?
The IO has said that he has yes
Stated
that the contraband was forwarded for sampling and certification. It has not been exhibited before this court during the trial. So section 52,
sampling
yes, and for certification of the inventory by the magistrate. So here in this case,
but the same not brought in evidence.
is not brought in
The
evidence.
same is not stated, no?
Not exhibited. Nothing has been exhibited to testify that section 52A has been complied.
Okay.
So in this case, you know, that has also not been complied. 42, 50, 51, 50, 51 and 52A has not been complied. So
50 is regarding search and seizure. 50.
50 is regarding personal search.
Personal search.
Yes. Section 50 is personal search.
Okay, personal search.
Yes.
Personal search.
51 is search and seizure.
Search and seizure 51.
51. 52A is disposal of narcotin, like for certification. 52A is sampling and certification of the inventory list by the magistrate. 52A. Yes. So these are the sections, Your Honor, which has to be mandatorily followed, which has not been followed.
Section 50,
Section 51,
51,
Section 52A.
52A, mandatory.
Yes, yes, and 42 also, Your Honor, that ground.
Section 42.
Yes.
Mandatory.
Yes.
All were not, all were proper.
Yes, yes.
So penalty will apply.
Yes.
Hence total non-compliance.
Total non-compliance. And regarding the fact also, Your Honor, this is the law. Regarding the chain of custody of the contraband, it has not been linked. Like from the BSF, it has been handed over to the police. From police, it was to Malkhana. From Malkhana to the FSL. This chain is broken, Your Honor. It is not properly explained. So the result of the FSL is of no consequence unless the chain of custody is proved beyond doubt by the prosecution during evidence.
No explanation, no?
Yes, sir. Malkhana register was not produced.
Yes. By the way, how many days are contempt in BSF camp?
It was on the same day, on which day.
On the day-
Yes, yes, yes. It was 4-2.
Now,
Yes.
PP should answer.
Yes.
How much time it's with in the custody of BSF in BSF camp from the time of recovery? Handed over to police on same day or on mute yourself?
No, not on the same day.
Yeah.
All right.
Why you are?
It was on 3. Yes, yes. It was on 3.
That also was broken.
Yes. Oh, it is all again broken.
Even in BSF custody in BSF, no?
Yes.
In BSF for BSF camp for 1 day, ma?
Yes.
Mm.
And thereafter from.
For one day from since recovery.
Yes.
Not explain, ma?
Not explained. And from the handing over the police to the production till production of before the magistrate.
Custody with police.
Yes.
Custody with police till production.
Yes. Before the magistrate.
Before magistrate, not
Proved.
not proof.
And thereafter, in fact, they have not produced the inventory only before the before this honorable court. So it is not understood where it was lying.
Rather inventory not produced. Hence. How the custody was not.
Yes. If I will just read the cross-examination of this IO PW number 11, Your Honor, it will be just clear everything.
He animated everything.
Yes, Your Honor. I just cross-examination of PW number 11. He said, Your Honor, cross-examination only. I will just read him.
Where is the deposition at?
No, I'll just read.
Yes.
Number 2, Your Honor, it is a fact that as per the statement of complainant, there was a prior source information. It is a fact that in this case, I have not seized any document to show if the source information was reduced into writing by the complainant prior to proceed to the PO. It is fact that I did not go to the BSF camp for any inquiry, but I have deputed SIA Nanang for the same. Number 6, it is a fact that there is no record in the court to show that the complainant had visited Nang Helam PS. And I took up the investigation on 10/2/2022 at around 11. It is a fact that since I took up the investigation on 10/2/2000, hence I do not know in what mode and manner the alleged seized contraband was packed and sealed. He is the IO, Your Honor. I prepared the inventory list on 10/2/2022.
Okay, much too late, no?
Yes, Your Honor.
Okay.
I was in a station on 4.
Inventory,
Yes.
prepared by IO.
Yes, Your Honor. Yes. He has said that I prepared the inventory.
Moreover,
Yes, Your Honor.
he is not part of the recovery,
This IO.
is it?
He is not this one. No, but he has to prepare the
Not
inventory.
too late,
Yes.
right?
Yes.
Okay.
Now he has said that I prepared the inventory list on 10/2/2000. There is no, it has not been exhibited. He has said so. It is not there only. He has said
The same
not available on record.
not exhibited, no?
Yes, yes. I was in a station on 4/2/2000 till 10/2, but on 4/2 I was engaged in law and order, and I was in the police station. I have no knowledge where the alleged contraband, Unit 11. I have no knowledge where the alleged contraband was kept on 4/2/2022 until evening of 4/2/2022 when then. Yes. I am not aware where the seized contraband was kept since its recovery till its re-seizure by SI. So they are re-seized by seizure list. I have not exhibited any document to show. I have not exhibited any document before the court to show where the contraband was kept from 5/2/2022 till it was sent to FSL. FSL it was sent on 27/10/2022. It was sent on 27/10/2022.
Send to FSL
On 27/10/2022. And I have not exhibited any document to show from whose custody the alleged contraband was forwarded to magistrate for drawal of sample.
on 14.
Yes, Your Honor. The re-seizure of contraband by police was from the possession of BSF. I have not seized any document from BSF to show they have seized the alleged contraband from any of the accused person.
That is point number
16, Your Honor.
16.
In this case, there was no Panchanama prepared to show from which place and from which part of the accused the recovery was made. I have not prepared the rough sketch map of PO, but it was prepared by EO. It is a fact that as per seizure memo exhibit P2, there was no blue color pouch seized by the police from the possession of BSF, nor any black pouch bag. Yes. So this one, Your Honor, where the contraband was kept, but it is not available in the seizure list.
So it contradicts PW1.
Yes, Your Honor.
PW1, PW2 also said about
Yes,
the
yes,
patch.
yes, yes.
What about PW3? Did he say?
He said that he has no much knowledge. 21. The complainant had not stated in his statement if any option was given to the accused person prior to conducting their physical search. So it was not given only, he has said. I have not explained anywhere, number 23, I have not explained anywhere as to why the inventory list was not prepared. Now he is saying, you know, as soon as the
Which one?
23.
Just now you said that
Yes.
that the back carried by the thoroughly checked.
Yes.
That one is important for
It is a fact that complainant has not stated that the bag of Pranjal Marak was opened by himself. Yes, yes. So that means it was checked. I have not explained anywhere as to why the inventory list was not prepared as soon as the alleged contraband was seized. So even if suppose they have floated some, but there has to be some explanation, you know, why it was not complied. So that
what number?
23.
23.
In certain circumstances, it is
Comply what?
that inventory list, why it was not prepared. The seized, number 24, the seized alleged contraband was handed over to me by the inquiry officer. I have not exhibited any document to show that the seized alleged contraband was handed over to my custody at any point of time. Now, inside, they are just exchanging the custody, but there is no documentation. How this IO has taken the custody, how the EO has taken the custody.
Okay, no explanation how it came to
The custody of the, yes,
how it
yes,
came
to the custody of IO. There is no document of handing over and taking over.
of IO as there is no document of handing over and taking over.
Yes, yes, yes. Now you are at 27. I have not reflected the manner and mode of packing and sealing, nor did I reflect that the same was produced in the same condition in the inventory list. However, I have simply reflected packed and sealed in the envelope.
Number
27. So, suppose, Your Honor, if something is, even if it is recovered from the BSF, or it was seized from the BSF, it has to be properly packed and sealed so that it will be opened before the magistrate to maintain the sanctity of the contraband. So now, how they are handling and in what manner and mode it was packing, it was also not evident from the record that it was so packed and sealed and was produced before the magistrate in that condition. And thereafter the sample was taken.
but here the manner of what was not packed,
No, he has not reflected anywhere in the record also.
but not
Reflected.
mentioned in
Yes,
the
they have to prove that yes, it was intact.
mentioned it was packed and sealed.
Yes,
Huh?
yes, yes, yes.
Packed and sealed.
And yes, sir. Now, point number 30. Now, it says that, point number 30 says that, I have not seized any document to show that the complainant has informed his superior officer in writing. Suppose even if information is there, and if something is seized and recovered, entire report has to be
Proofs,
57.
there was no.
No,
Proofs, no.
compliance of section 57 is also not there.
Section
57. 57, yes, yes. It says that report of arrest and seizure. It says that whenever any person makes any arrest or seizure under this act, he shall within 48 hours next after such arrest or seizure make a full report of all the particulars of such arrest or seizure to his immediate official superior. So suppose BSF has done, that complainant has done, he has to inform to his immediate superior officer that I have done all these things. So it has not been complied. And 32, I do not know at what time the BSF have taken the accused person to their camp. Now, in IO has he has to clarify everything, but he is saying that he do not know. I could not recall whether the seized contraband was forwarded to the court at the time of forwarding the FIR and the seizure. It is also not little doubtful that when did they forward this contraband to the court. It is correct that the alleged
you are reading point number
34.
34. It say I could not recall whether this is from was forwarded to court
At the time of forwarding of the FIR and seizure list.
Okay. And what is your content?
My contention is that, suppose even if some articles is seized, FIR and everything, the article also has to be produced before the court for seal and mark. So he has not proved, the IO has not proved that it was so forwarded. Only he said that I have forwarded the seizure list for seal and note on 10/2/2022, and that also 10/2. It was seized on 4/2. He has sent on 10/2/36.
36.
Yes.
10 is what? 10
10/2 he has forwarded, but it was seized on 4/2. Why there was so much?
While on which day?
4/2/2022.
Recovery you mean to say?
Yes, yes, yes.
Sure.
Yes, yes. Seizure list was prepared on 4/2/2022.
Did you not explain, huh?
Not explained. Now they have also said, Your Honor, that the preliminary test was done by the BSF. Just oral evidence only. They have said the orally that preliminary test was done. There is no report.
Yes, sir.
Yes, IU is also saying that their preliminary test was done by the BSF. Point number 37. And it is a fact that I do not know, no proof. 38 also, Your Honor, it is a fact that I do not know from which of the arrest contraband that sample was drawn and tested in preliminary.
Point number what? Where it says BSF has tested? 38.
Yes, ma'am. 37. It says that the preliminary test was done on 4/2/2022 by EO at BSF camp, inquiry officer, Lanam. But he has also not exhibited any such.
Limited point number, I do not know.
Yes. The preliminary, he has said that it was done, but it is not there in the record. It is a fact that I do not know from which of the arrest contraband, yes, that sample was drawn and tested in preliminary testing. There is no preliminary test report. Now he is admitting also, Your Honor, that there is no preliminary test report prepared by the EU.
Point 39.
Yes.
Limited.
Yes. And now he has said, Your Honor, since I have not reduced into writing, hence I have not exhibited any document to show where the sample was kept.
Point number?
40, Your Honor. Since I have not reduced into writing, hence I have not exhibited any document to show where the sample was kept till it was sent to FSL.
The custody.
Custody is, chain of custody is broken, yes, from here also. Yes, sir. Now he is saying that, Your Honor, 42, the samples were forwarded by SP to FSL on 17/2/2022. So IO is saying that it was forwarded by SP, but there is no actually, Your Honor, evidence that it was forwarded by SP. And even if it is forwarded, it was on 17/2. That means after 15 days. Before he has said, Your Honor, that it was forwarded to 27/10/2022. First they have forwarded, I think, Your Honor, in Shillong. Shillong, yes, there was missing and this all. Yes, yes. So most important is that 27/10/2022. Each and every day they have to explain that where it was kept.
To FSL when?
To Guwahati, Your Honor, 27.
27 in when?
27/10/2022 in Assam.
To see FSL, no?
Yes, yes, yes. But first they sent here Shillong.
Yes.
Yes, on 17/2022. So now he is saying that only the sample, but the remaining, Your Honor, remaining he said that it was kept in Malkhana. This whichever has been produced before this honorable court, he has said that 44. Yes. He is saying that remaining contraband were kept in NDPS Malkhana. So, but he has said that I have not exhibited any document to show that it was kept in NDPS Malkhana, Mokarwat. No register has also been exhibited. And 46 also, Your Honor, important point number. It is a fact that I have not exhibited any document to show where the returned sample from FSL was kept till it was sent to CFSL.
What, point number?
46.
46.
Yes.
Happened, yeah?
It is a fact that I have not exhibited any document to show where the returned sample from FSL was kept till it was sent to CFSL. However, I have kept it with me as a sealed and packed condition. He is saying that it was. Yes. Yes.
is all that, na?
Yes.
Required temperature or not?
Yes, yes.
So accepting.
Accept.
Yes.
Yes. You know, I will just point out one more cross-examination of PW number 1, you know. Only that one that his body search was done. The complainant cross-examination, Sonal Bora, on 11th May 2026, after the IO. It was done because it was
Where? PW1?
PW1. PW1. Cross-examination was not concluded for the first time,
Oh,
so
because.
yes,
Okay, on which date?
11th May 2026.
Yes.
So here, Your Honor, point number 13 and 14. He has admitted also that it is correct that the body search of both the accused person was done by us.
Wait, huh?
Yes.
What is that?
11th May 2026.
Yeah.
Yes, sir.
Okay. Point number?
13 and 14. It is correct that body search of both the accused person was done by us. So that means body search has been done. Had they checked only the bag, section 50 would not have attracted, but since they have done, so now it will apply. And he has said also that it is correct that the whether it is recovery was there or not, that is immaterial.
Section
50.
section
50.
50.
Yes, whether recovery is there or not, that is immaterial.
And then recovery was from the
Yes, bag. Yes, whether that is recovery is immaterial. I think you all is aware that what was that judgment? State of Rajasthan permanent. Had they not searched the body, then 50 would not have come here.
yeah,
But yes, bag only if they said that okay, bag was he was given and we checked the bag. But they have searched the body also. Nothing was recovered. And then section 50 will apply. Then he has said that it is correct that option for the accused person whether they want to be searched
oh,
by the
yes. Okay, all right.
Yes.
Okay then.
It
Yes,
is,
Madhu?
he is saying that it is correct that option for the accused person whether they want to be searched by the magistrate or they was not given to the accused person before searching them.
Point number
14, Your Honor.
40?
14, 13 and 14.
Yes.
So that's why I am pressing upon this honorable court that since body search has been done, 50 is mandatory. Section 50, you know, is the basic fundamental right, which is also provided under NDPS Act also. So nobody can just check the body of anybody. So this is the situation, Your Honor. I will just that the other mandatory provision already Your Honor has highlighted, mention about that one. So I'll just give regarding Malkhana and this.
Okay, the recovery was not from body,
No.
from the person,
Yes.
but it was from the back.
Yes.
However, change of custody has to be
Yes.
the ratio has to be the packing and senior ratio,
Yes.
then the preliminary test, all that information
I'll just read
are
you.
mandatory.
Yes.
Mandatory provisions. which has to be
Yes,
complied.
that one, just kindly see, page number, this paragraph number 15. We see that paragraph number 15. It is very clear that thus, if merely a bag carried, I have
Where is that?
15. Yes,
Where is it?
351 page
Yes,
number.
it is merely a bag.
Yes. Thus, if merely a bag carried by a person is searched without there being any search of his person, Section 50 of the NDPS Act will have no application. But if the bag carried by him is searched and his person is also
The
searched,
bag is he carried.
a bag is also in this case bag. Yes.
PP, the bag
Yes, ma'am.
The bag was carried.
Yes.
Scan it.
It's not that the bag was
Yes, ma'am. Yes,
seized
ma'am.
from the dicky of the car or
No.
from anywhere else.
Yes.
But the bag is
Already wearing
hung
here.
on his shoulder, right?
Yes.
Carried by Panchat Mara.
Carried.
And he has admitted also Sonal Bora in paragraph 15 of the clause.
Bag carried by Kanjar, no?
Yes. So otherwise also it will apply.
So the section 50
50.
will apply, no?
Yes.
I was just thinking, I remember the evidence.
Yes, sir.
Okay.
Yes, this one also I'll just give you regarding now.
Sometimes we do have cases where the bag was found from the dicky of the bus
Dicky,
and all.
scooty,
That is
yes.
something else.
That is not required. 50
That is something else.
Yes. Section 50 will not apply on.
But here we carry.
Yes.
So I then this second one,
This second one here, that regarding chain of custody.
change of custody,
Yes.
Para,
Para 3. It is one page judgment only. It is reported in 2005 SCC. Yes, Gurmail Singh. Paragraph number 3. We have perused the judgment of High Court apart from other reason. We find that the link evidence adduced by prosecution was not at all satisfactory. In the first instance, though seized articles are said to be kept in Malkhana, the Malkhana register was not produced to prove that it was so kept in Malkhana till it was taken over by such and such. We will further find that no sample of seal was sent along with sample to the excise. This is also not there. Therefore, there is no evidence to prove satisfactory that the seal found were in fact the same seal as were put on the sample bottles immediately after seizure. So regarding, I am just on Malkhana register. So these are the all that. Yes.
okay, if you would like to reply.
No, ma'am. Except that this case was there during COVID time, and most of the investigation were.
Poor coronavirus.
COVID. Supreme Court has not given exemption.
All of the accused.
Only for limitation it has been given.
And all of the accused got corona.
During COVID time.
So it was difficult.
Even one of the accused, even one of the accused got COVID. So you mean to say,
only that.
That's why the fee here, to comply. That's why the fee here to comply. Okay.
Most of the investors lapse into the investigation. All those that.
Supreme Court relax only on the limitation, no?
Yes, ma'am.
I feel sorry for coronavirus.
Yes.
I think you have to get one chandelier in the shape of, now they are making, I think of all the products,
Yes, ma'am.
especially chandelier, house chandelier.
Yes, yes.
So many coronavirus shape is there. You need to take that. So that remind everyone. Okay, nevertheless, it's true, Supreme Court has relaxed only on limitation.
Yes, yes.
Okay, okay, nevertheless,
Yes, ma'am.
yes, I'll give judgment on 31st. Okay,
Okay, ma'am. Yes, ma'am.
I wish I could give today itself.
Good day, ma'am.
Yes, I wish I could give today itself, but then our staff, they have got training
Oh.
on that, send my head on that regarding one, and NPSC.
Yes.
So it's so very
Yes,
hard
yes.
on my part
Yes.
to restrain them here.
Yes, yes, yes.
More.
Yes.
They have to know what
Yes.
is their rights in order to make contributions for their savings and all. So I have to allow them to go for the training.
Yes.
By myself, I'll not be able to type.
Yes.
I'm not fast. I'm not. So I'll finish. I'll give the judgment on 31st. Bring your accused on
All right.
31st.
Yes.
Okay.
Yes.
Okay. No promise, no thing, and no judgment. I'm not judgmental at this stage. I don't know.
Yes.
Maybe after I produce the file, then
Yes,
it's
something-
really coronavirus.
Something.
That is the main culprit who has. Everyone got blindfolded.
Yes.
Okay. Nevertheless, thank you.
Obliged.
Thank you for the
Assistance. Yes.
hearing, because I want to give judgment.
Yes, yes.
Okay, thank you.
Obliged.
Good. Okay, Pipi.
Obliged, ma'am. Good day.
Good day.
Yes, ma'am.
Good day. Don't take it hard upon you. You've tried your level best. What to do? Coronavirus is the main
Yes,
culprit.
ma'am. All the.
Okay.
All the. I
Why
have
is
no
that
time to try from the beginning. You know,
The
like.
evidence of SI Eleanor, right? Just now I've seen. SI Eleanor, he said about one of the accused got coronavirus had to be kept in isolation, quarantine. Have to be quarantined and all. But then poor Corona did not restrain anyone to comply with the procedure, excepting for the
Yes, ma'am.
Okay. They could have done it on
Yes, ma'am.
financing, it says like that. They could have done it regarding this it says, if not immediately, at least information have to be related later on. But it has to be before the person accused before the magistrate. That has to be done. But if total compliance, okay, thank you. See you on 31st.
Thank you, ma'am. Yeah, good day, ma'am. See you.
But
Yes,
people
ma'am.
are seeing every day. Okay, good day. Done.
Good day.
Yeah.
Done.
That is for the I presented by the defense. Okay.